People usually apply to register trademarks because they are concerned about potentially losing clients and customers to a competitor who has similar branding. And trademarks can help prevent the loss of these clients and customers by ensuring that the trademark owner has the exclusive rights to use those trademarks, but that is if and only if the trademark is registered on the principal register, not the supplemental register. So when you apply for a trademark, you will want to make sure that your trademark gets on the principal register, and here's how. Hey friends, welcome back to my YouTube channel. I'm so glad you're joining me today. I'm Faith Mitton, an attorney on a mission to simplify brand protection for entrepreneurs and business owners. On this channel, you will find tons of free, easy to understand, and practical insight about trademarks to help you learn how to protect yourself and to stay on the right side of the law. Now, today, let's talk about this issue of differentiating the principal register from the supplemental register. This is a fundamental topic you need to know about if you're concerned about registering trademarks at all. When you initially apply for your trademark with the USPTO, that application will be for the principal register. But if your trademark does not qualify for the principal register, then you may have an opportunity to place it on the supplemental register. And in fact, you might be watching this video because you are in that exact situation. You've applied to register your trademark. The USPTO has told you, nope, no principal register for you, but you can get on supplemental. And you need to figure out if you should accept the USPTO's recommendation to place your trademark on the supplemental register. If that's the case, I'm especially glad that you are watching this video because there are some important things for you to consider. But let's start with the principal register. The principal register really is only for those trademarks that are considered to be inherently distinctive. In another video that I've posted to the channel, I go into much more detail about how to rank trademarks based on strength because there are different categories for strong trademarks versus weak trademarks. I will tag that video here and link to it in the description. But in that video, I talk about how trademarks that are inherently distinctive are strong trademarks. And there are three types of inherently distinctive trademarks. These include fanciful trademarks, arbitrary trademarks, and suggestive trademarks. Fanciful trademarks are those which are made up words. Arbitrary trademarks are those which do not have any logical connection to the products or services they're used to promote. And suggestive trademarks imply a connection to the products and services they're used to promote. I'm not going to go into any more detail than that. If you want more detail, please go and check out that other video that I mentioned. I will tag here and link to in the description below. But the point is that the owners of these kinds of trademarks don't need to prove in the trademark application that they have really strong or unique trademarks. The USPTO will assume that to be the case if in their analysis of the trademark, they determine that it is either fanciful, arbitrary, or suggestive. And these kinds of trademarks, if approved, will go on the principal register, which is the only one that gives trademark owners the benefit of exclusivity. That means that they can stop their competitors from using similar trademarks, which could confuse their clients and customers, resulting in the loss of sales, reputational decline, or even worse. And this exclusivity, to me, is the main benefit of applying for a trademark registration. But aside from exclusivity, there are many other benefits of getting on the principal register. These include using the Circle C trademark registration symbol, blocking applications for confusingly similar trademarks, presumption of validity and ownership in trademark disputes, the potential for incontestability, the option to record the trademark with U.S. Customs, increased statutory damages in trademark disputes, and the use of the U.S. trademark registration as a basis for seeking international trademark protection. Now, switching gears, let's look at the supplemental register. The supplemental trademark register really is only for those trademarks that are considered to be descriptive, which is a topic that I've talked about in that other video that I mentioned earlier about trademark strength. But descriptive trademarks are considered to be weak trademarks because they say something really obvious about the products and services themselves, the target audience for the products and services, or the company behind the products and services. I won't go into too many examples or really any examples of what descriptive trademarks are because I have a whole separate video on that. Descriptive trademarks are not necessarily obvious, and there are many ways that a trademark could be considered to be descriptive. So to learn more about that topic, check out that video, which I will tag here and link to in the description. But as I said before, descriptive trademarks are weak trademarks because they say something very obvious. You can imagine that these are the kinds of things that people think about right off the bat when they sit down to brainstorm a new name, tagline, or other portion of their brand identity. So in other words, these trademarks are really popular. And because they're so popular and so commonly used, there is a high degree and high potential for confusion because if 10 businesses, for example, have the exact same name or very, very similar names, how are people going to be able to differentiate those businesses from each other? It's going to be very hard. That's why these are weak trademarks and they're very difficult to protect. So these trademarks, which tend not to be very unique or creative or clever, may still be approved by the USPTO in the trademark registration process, but if they are, they will be placed on the supplemental register. Trademarks on the supplemental register do not give their owners the benefit of exclusivity, right? Because these are really commonly used trademarks, very popular. It would be unfair to give a single business the right to use it exclusively. And so basically, the supplemental register is the equivalent of a participation trophy for trademark applicants. They're really undesirable and they're not worth all that much. But is there some sort of benefit to getting on the supplemental register? Like, there has to be something, right? Otherwise, the USPTO wouldn't offer it. And yeah, there are some benefits. These include use of the Circle R trademark registration symbol, blocking applications for any confusingly similar trademarks, and using the US trademark registration as a basis to seek international protection. As you can see, this list is a lot shorter than the list of benefits for the principal register. But although descriptive trademarks on the supplemental register are not inherently distinctive the way that fanciful, arbitrary, or suggestive trademarks are, they can become distinctive over time and be associated with a single business rather than a bunch of different businesses in a particular industry. But it takes a lot of time, money, and effort to acquire distinctiveness. It isn't something that happens automatically just because you've been in business for a certain number of years or because you've been using a trademark for a certain amount of time. To be able to claim acquired distinctiveness, you will have to file a whole new trademark application with the USPTO and submit proof for how your trademark has become distinctive and unique for your business. And the USPTO doesn't always agree with trademark applicants who are claiming acquired distinctiveness. So it can be tricky. That's why getting on the supplemental register with the hope of eventually transitioning to the principal register can be a strategy that backfires. So what do you do if you're in a situation where you've applied for your trademark, the USPTO has rejected it for the principal register, but is offering you the supplemental register? If you are in that situation, I implore you, I beg you to consult with a knowledgeable trademark attorney because USPTO doesn't always get it right. Sometimes trademarks they think are descriptive and weak actually are inherently distinctive and belong on the principal register. A trademark attorney can help you do the relevant analysis to figure out if there's a path forward for you to get your trademark on the principal register rather than accepting the supplemental register. Because if you accept the USPTO's recommendation to place your trademark on the supplemental register, you are essentially admitting that you don't have a unique trademark, that it isn't created, that you don't have the exclusive rights to use it. And all of those things can backfire on you in a trademark dispute. So as I mentioned earlier, it's a good idea to reach out to an attorney for assistance to determine whether this supplemental register thing is a viable avenue for you or not, because while I have mentioned some things for you to consider here, this is only a summary, and like all summaries, a lot has been left unsaid. And that's a wrap. If you enjoyed this video, please give it a thumbs up. Be sure to subscribe to the channel for more trademark content and to turn on notifications so you never miss when I post a new video. If you have thoughts or questions to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.